My name again is Steve Crampton. I serve as senior counsel to the Thomas More Society, a public interest law firm championing life, family, and freedom. I've practiced law for over 40 years, specialized in constitutional law in both state and federal courts for over 32 years. Admitted to practice in 3 different states, several federal district courts, most federal courts of appeal, and the United States Supreme Court. I've assisted in drafting and defending personhood laws in several states, authored a law review article on the topic some years ago, testified before both state legislatures and the U.S. Congress, and I am currently engaged in full-time pro-life litigation and assisting in legislation all across the country, including here in South Carolina, from the lowest state trial courts to state Supreme Courts to the U.S. Supreme Court. Now, as to this particular bill, Senate Bill 323, the care and protection of the most vulnerable among us is perhaps the truest test of a civilized society. This bill extends the equal protection of the laws to the unborn, who are, in fact, the and most vulnerable members of our society. In fact, even back as far as our nation's charter and the Declaration of Independence, the first duty of the state is decreed as to protect life. We hold these truths to be self-evident, that all men are created equal, they're endowed by their Creator with certain inalienable rights, and that among these are life, liberty, and the pursuit of happiness. It is to protect and preserve these rights, to secure these rights, that the government is instituted among men. So I applaud this committee for undertaking this project and look forward to its eventual passage. First on the legal agenda is the constitutionality of what this committee is undertaking. And I am here to assure you that there is nothing in federal law that prohibits this state from moving forward on this kind of bill. Since the Dobbs against Jackson Women's Health Organization decision in 2022, which, as y'all know, overturned Roe against Wade, there is no impediment whatsoever in federal law. While the Dobbs decision did not explicitly declare the personhood of the unborn, it certainly opened the way for states like South Carolina to do so, virtually inviting legislation like Senate Bill 323. And as we sit here today, several other states have recognized the personhood of the unborn in one form or another. Perhaps as many as 17 have established rights for the unborn either by statute or by judicial decree, and some 24 different states contain personhood language protecting the life of the unborn in their abortion laws, as SB 323 will do. And this is, in fact, as it should be. Historically, our laws did provide protection for the unborn to the same extent as to born children. It was only really with the advent of the abortion industry that courts began to reconsider and efforts were made to render the unborn non-persons under the law. In fact, as recently as 1968, only 5 years before the decision of the court in Roe against Wade, the U.S. Supreme Court held that the Equal Protection Clause applied to illegitimate children because, listen to the language of the court, they are not non-persons. After all, they are humans, alive, and have their being. Those criteria apply equally to the unborn here today. So, Senate Bill 323 is not some far-out extension of the law that's never been undertaken before. In fact, it is a restoration of the common sense undertaking that extends the protection of the law to children in the womb, unborn. They happen to be, to this day, in most states, still the only class of human beings the law has failed to protect. Moreover, South Carolina, like many other states, have long recognized the unborn as persons in other areas of the law. Consider inheritance laws, for example. fetal homicide laws, child endangerment, and so on. So again, SB 323 is not some new radical undertaking. Now, I want to address in particular some of the criticisms and concerns that have been raised, and note for the record that many of the comments this morning as we sat through comment time seemed to suggest a great deal of misunderstanding about what this bill does and doesn't do. In particular, there is some concern raised by even other pro-life groups that holding mothers accountable for their part in aborting their own unborn children is somehow an egregious wrong. I would respectfully suggest that it is in fact just and logical to extend the full protection of the law to the unborn, especially in a day like we find ourselves today, where abortion is no longer only rendered in an abortion clinic or facility. In fact, mothers all over the land now have access to chemical abortions, abortifacients, and can conduct abortions in their own home. If we fail to extend the protection of the law to the unborn as it pertains to mothers, then you really have an unequal protection of the unborn across the board. Only those who are taken to an abortion clinic are protected. Those who remain at home and let the mother proceed are left unprotected. That is unjust, and it is frankly a violation of the Equal Protection Clause. So, while we certainly concur that there are many mothers who end up aborting their children as a result of being coerced, being perhaps even lied to, being threatened physically with harm, and have then no choice, to impose a blanket immunity to all mothers because some are coerced is itself illogical and, again, unprincipled here. So our position here, and this bill, I think, advances this cause in the following way. Mothers are rendered culpable for their own acts. However, there is immunity granted when they cooperate with the prosecution. And, of course, extenuating circumstances, such as coercion, can always be addressed both with the solicitors and in a court of law. Furthermore, the bill explicitly allows the defense in the event they suffer threats of physical harm. So there is abundant provision for the due process, really, to play out for mothers who are accused in the context of aborting their own children. And I would suggest to this committee that to treat the mothers as always vulnerable, always coerced, or really unable to resist the participation in the abortion is really a throwback to the time when women were denied citizenship almost altogether. They were entirely dependent on their parents. There is a paternalistic quality to the notion that all women should be immunized from this bill that is simply outdated. It should not be the law. I think SB 323 does a very fine job of striking the balance and allowing defenses while not granting immunity forever. Moreover, there is, I think, a gross misrepresentation, gross misunderstanding in this bill with respect to the accusation that mothers would somehow face the death penalty. Nothing could be further from the truth. This bill explicitly provides that the maximum penalty is 30 years imprisonment. Moreover, the section right before that section in this bill states that in the event of inconsistencies, contradictions between this bill and any other legislation, the provisions of this law shall prevail. So to the extent anyone attempts to prosecute a mother for capital murder, they would be immediately stopped under that provision. SB 323 prevails. And remember that that's only up to 30 years. The fact is there is no minimum penalty imposed here. So it could be, in many cases, mothers face no jail time whatsoever. Again, there is much testimony and concern with respect to this bill's failure to provide a rape and incest exception. Again, I would refer this committee back to first principles. The job of the state is to protect life, to treat that innocent life with the same respect and dignity that born children and adults enjoy is the fundamental premise here. Consequently, that a woman suffers an egregious harm at the hands of a relative or at a stranger who perhaps has raped her is a terrible wrong, no question about it, and that should be addressed. But you do not punish the child for the sins of the parent. The father is the wrongdoer, not the child. You do not execute the child for the rape committed by the father. So this bill, again, I think rightly divides the situation and sets forth the law that applies across the board. We honor life. We protect life in the womb.